Judges are not immune from criminal prosecution under the International Criminal Court. And insofar as this judge is working in collusion with the DSS and the government to punish Nnamdi Kanu as a political prisoner by refusing to address the central dimensions of the flaws in the amended charge, clearly indicate she's taking her orders not from the law, she's taking her orders from DSS. The idea that she would consult with the prosecution and not the accused in deciding whether to move forward is totally outrageous. In the United States or any civilized system, she'd be required to recuse herself immediately as having compromised the appearance of justice.
A federal high court in Abuja on Wednesday, November 10, 2021, adjourned the trial of the detained leader of the indigenous people of Biafra, Nnamdi Kanu, to January 19, 2022. There was a mild drama at the court as Kanu's team of lawyers staged a walkout over the refusal of operatives of the Department of State Services to allow some members of the legal team gain access into the courtroom.
Stop a mild protest that Nnamdi Kanu's lawyers, at least 6 of us, should be allowed inside. So while we were outside deliberating on this, the judge ordered that the courtroom be locked, and we were locked out. Our books were inside, wig and gown, everything. So it's not as if we abandoned the court. But the judge conducted the hearing in our absence and adjourned the matter to 19th and 20th January next year. We consider this to be a travesty of justice and a flagrant violation of Section 36 of Nigerian Constitution and other sections of Nigerian law that guarantee right to counsel to Mazi Nnamdi Kanu. And we're not going to take this lying low. We're going to go back to the drawing board and consider bringing forth very strong countervailing legal measures against the unfortunate decision of today.
Nnamdi Kanu, who was brought into the courtroom at about 9:52 a.m. and shortly before his case was called up, he decried the refusal of security agents to allow some members of his legal team, especially his lawyer from the United States of America, Fein, to enter the courtroom. Kanu told the trial judge, Justice Binta Nyako, that Fein, who was handling a case for him in the US, was around to witness his trial. He said, "I have an ongoing case in the US. I have not been allowed to see him. He is here to see me and to observe the proceedings. He has been to the DSS to see me, but they denied him access to me." Addressing newsmen on what transpired in the courtroom, Kanu's lead counsel, Fein said,
"Today, we are all the media. We are also familiar with the constraints we are usually exposed to lawyers. Last adjourned date, of course, you can bear me witness. The media were not allowed inside access to the court, but we insisted this time they were in court. So that was part of the things we were able to achieve. Then today, lawyers who were in court, who managed to gain access upstairs, about 8 of us, were not allowed access to the court. So we are outside. Our wig and gown were inside the court. Our books, bags were inside the court. All of us were at the door of the court, trying to resolve this issue. When the court came in, and they are now called up the case, and without allowing us access to the court, we were locked up, and the matter was called up and adjourned to January 19th and 20th. So the court is not oblivious of the fact that the matter has come up today for hearing of objection to the charge. The court is also not oblivious of the fact that we are in court today, and we are in court to defend to move our application challenging the competence of the charge. Our client was called. We are told our client was called by the court and the prosecution. They have a discussion, portion upon which they done the matter to January 19th and 20th. We don't know what they discussed. So this is a clear case of flagrant breach of his fundamental right. It's worse still when we're in court. Even ordinarily, even when lawyers are not representing him, the federal government is under obligation to appoint in line with the extant laws, to appoint a lawyer to represent him in this case of this nation. But in this case, we're in court. And we've been lawyers in our record. The court was simply called us. Ejiofor, come, go and call Ejiofor, let me know what's going on here. Because the court will not deny the fact he has seen us from the camera. He saw from the camera. The court was feeling aware that we're in court. So, calling the case up, adjourning to January 19th, without hearing our application, founded on solid ground, challenging the competence of the court, my brother, is the height of privacy of justice. Exactly. And we legal team are going back to think twice. Because as it stands today, I don't think we have implicit confidence in the court to continue with the hearing of this case. I can say that to you authoritatively. Yes. So, I can assure you today, we are going to activate necessary processes to ensure that this case is heard and it must be heard speedily. We can't wait till January to hear this application. We must initiate the process today to ensure that if the court is not willing to go on with the matter will stay called the case with our central judge, who will hear this case as quick as possible.
Ejiofor also noted that the IPOB leader has not committed any offense against the law, adding that they have challenged it in the court.
There's no charge before the court of substantially setting the fact of offense he committed. He has not committed no offense unto law, and we have challenged that effectively before the court. We have filed our processes, and they'll file their water counter affidavit before the court.
He said the court should have given them the opportunity to be heard today and not be locked out of the courtroom.
The court ought to have given us an opportunity to be heard today, but unfortunately I've not seen that in the history of my practice. When lawyers will be in court and will be locked outside the court. This is my first time of seeing such, and it tells what I don't want to say further than this, but I know we're going to take it up from there.
Also, Bruce Fein, the IPOB leader's US lawyer, said the reason why the lawyers were locked out of the courtroom was because of him.
The lawyers were locked out because of me. Bruce Fein, I'm the international lawyer of Nnamdi Kanu, come from the United States, been formerly Deputy Attorney General. I've spent a lot of time in courts, and this is a true travesty. It doesn't come close to satisfying international law as well as the Nigerian Constitution. Nnamdi has been denied his right to counsel under the Nigerian Constitution, the International Covenant on Civil and Political Rights, the Universal Declaration of Human Rights, clearly requiring immediately. He's currently being punished. He's never had a hearing. He's been charged with actions that don't even make a crime. And he's 6 months at least in solitary confinement without access to medical care. This is a punishment before trial? I mean, this is a chapter out of Alice in Wonderland. And I want to underscore, judges are not immune from criminal prosecution under the International Criminal Court. And insofar as this judge is working in collusion with the DSS and the government to punish Nnamdi Kanu as a political prisoner, by refusing to address the central dimensions of the flaws in the amended charge, clearly indicate she's taking her orders not from the law, she's taking her orders from DSS. The idea that she would consult with the prosecution and not the accused in deciding whether to move forward is totally outrageous. In the United States or any civilized system, she'd be required to recuse herself immediately as having compromised the appearance of justice. Anyway, that's all I'll say for now, but it's quite clear, for whatever reasons, the Nigerian government has placed Bruce Fein on the blacklist. Maybe I'm the most feared man in Nigeria, and all I'm here to do in a respectful way is to present the law. And if they have any concern for the law, they should welcome that. I'm not demanding that I be the judge, just permitted to make arguments respectfully to give the other side an opportunity. That's how civilized justice works. Nigeria apparently doesn't want to subscribe to civilized justice.
With lawyers locked out of the courtroom, Justice Nyako, during the case reading, asked the IPOB leader if he was ready to conduct the proceedings himself in the absence of his lawyers, of which he said no. However, the counsel for the federal government and director of public prosecution, MD Abubakar, urged the court to proceed with the trial in the absence of Kanu's lawyers. Abubakar told the court that the matter was fixed for the hearing of an application that was filed by the defendant. He argued that since Kanu's lead counsel, Fein Ejiofor, who was initially inside the courtroom, walked out with his team shortly before the arrival of the judge, his pending application should be deemed abandoned. Justice Nyako, delivering a short ruling, expressed displeasure over the conduct of Kanu's lawyers. She declined to dismiss the pending application and rather adjourned the case till January 19th and 20th, 2022 for trial.